Hello, and thank you for checking in with us today. Today we're going to be talking about bankruptcy. Now, there's basically two types of bankruptcy for most individuals. There's more than that, but we're going to focus on two because virtually 99% of the population is going to cover. The first type is Chapter 7. Many people refer to this as complete bankruptcy. The second type is Chapter 13. Sometimes this is frequently called debt consolidation. Now, which one is best? Well, it depends on the situation. It's very similar to comparing a Phillips head screwdriver and a straight edge screwdriver. One is not inherently better than the other, and you probably don't really have a favorite type of screwdriver. Very similar with bankruptcy. So there's not a right and there's not a wrong. It depends on the situation. In my opinion, Chapter 7 is the best type of bankruptcy to do if you can. The reason for that is Chapter 7 has some very good features about it 13 doesn't. Number one, Chapter 7 lasts approximately 90 days to 110 days. Basically call it 100 days. Now, Chapter 13 lasts 5 years. So Chapter 7 is quicker. Number two, it costs less money. We charge approximately $1,200 to do a Chapter 7 bankruptcy. The attorney's fees set by the court in the Southern District of Alabama are $3,000. So you'd have to pay that plus the filing fee. So you're going to be looking at about $3,324 regardless of what you pay with the trustee. So it's roughly 3 times as much. The third reason is it's simply easier. Because it lasts 5 years, there's a lot more hoops you have to jump through to do a Chapter 13 than you do a 7. Now, that being said, there's 8 reasons why you would do a Chapter 13 over Chapter 7, and some of them are very good. Number one, you can only file Chapter 7 once every 8 years. So if you got in trouble 5 years ago and you get in trouble again, you got to do a 13. Number two, it costs, if you have too much equity in your house, you would have to do a 13, or in personal property. If you have $50,000 worth of equity in your home, you're going to be looking at a 13. If you got $5,000, you're allowed to keep $5,000 worth of equity, so if you have $5,000 or less, you can do a 7. Number three, you make too much money. It varies depending on the size of your family, and there's certain circumstances the court has the final say, but it depends on the amount of money you make. If you make less than $35,000 a year, you don't have a problem. You make more than that, it depends on the situation, the size of your family. Okay, next. Certain tax reasons are better to hit on the 13 to 7. Too complex to explain on this video, take my word for it. Next, if you need to stop the repossession of a car, you would need to do a 13. 13 allows you to stop the repossession and keep the car. Next, I guess number 6, stop the foreclosure of a house. Chapter 13 will stop the foreclosure of a house. Finally, if you're behind on your child support, Chapter 13 allows you to catch the child support up in a Chapter 13 and stay out of jail. And finally, the last reason is cram down. I want to explain how this works. Let's say 3 years ago, you have got to have purchased a car at least 910 days ago. But if it's 910 days or more, you can do a cram down. Let's say 3 years ago you purchased a car for $40,000. Let's say today the car happens to be worth $20,000, and you are owed $30,000 on it. So in a cram down, you can cram it down to where you only have to repay the $20,000, and you can spread the payments out over 5 years. Plus, if you are paying a high interest rate, like 15%, you could actually cram it down to where you only have to repay the current market value, which is market interest rate, which is probably around 6 in today's economy. Now, for now, I'm going to talk about Chapter 7. The first thing I'm going to talk about is exemptions. As we stated earlier, you get to keep $5,000 worth of equity in a homestead, $3,000 in personal property. If you have any money in a 401k or IRA, it's 100% exempt. You can have $1 million in there and you can keep it all. Number two, I want to talk about if you're being sued. If you're being sued, bankruptcy stops it. Called the automatic stay, stops all civil litigations against you. If you're being sued, we file a suggestion of bankruptcy and we stop the lawsuit. Next, do you have to go to court? Kind of. You go to what they call the Meeting of Creditors. This is a 341 meeting, and they're going to ask you a series of questions. I have them all on my website, or most of them. They can ask you within reason anything, but you can look it on there. Do you own a home? Have you listed all your personal property? Are you on the title to an automobile? Do you stand to inherit any property? Have you repaid any money to family members? These are the typical questions on that. That's what you can expect in the Chapter 7 meeting, or 341 meeting. Now, it's a formal meeting, meaning you're under oath, but it's held in a very informal manner. This is what the notification looks like. So if you get this, means you have to go to court, and you will have to go to court. Now, can you keep certain items that you have? You're buying a car. If you file a Chapter 7, can you keep your car? Yes, you can, because they do not want the car. They want the money. And if you're willing to sign a reaffirmation agreement, you can keep the car. So that should be taken care of. Now, you'll have to maintain the insurance and keep the payments up, but you can keep the car if you want to. Now, can people object to your bankruptcy? Yes, but they have to file an objection. Most objections are worked out without any real problems, but every situation is different, but you do need to be aware of they can object to your bankruptcy and try to stop you. Finally, let's say that you do not want to keep your car and you want to let it go back. You can do it. Now, before they can take the car back, they have to file a motion for relief from stay. Now, this is what a motion for relief from stay looks like. Let's say you're not going to pay for the car and they want it, they have to get permission from the court to get past the stay so they can get it. Remember earlier I said the automatic stay stops all civil litigation against you. They can't touch you with a 10-foot pole until they get the permission from the court. Now, are some debts non-dischargeable? Yes, they are. Certain debts are not dischargeable. Alimony, child support, certain willful torts, like even drunk driving injuries that are physical injuries, are not dischargeable. Because of that, certain debts are not going to be able to be discharged. Student loans are an issue that many people like to talk about. Those are difficult to discharge. Now, this is what you want to get. This is your discharge notification. This baby is important because it says all your debts have been discharged. When you get this, you get it and you hang on to it. The reason is down the road you may be trying to buy a car or finance something and a debt may not be listed or it may not show your discharge on the credit report. Get this to keep it so that you can show it to them that the debt has been discharged. In our packet, and all this is once again available on our website, I'd also ask you to read this. This is a bankruptcy terminology. Now, the bankruptcy terminology goes over certain terms. Like anything else, the more familiar you are with the subject, the better off it is. And finally, I have maps to the courthouse on our website as well. Now, the bankruptcy courthouse is held on 201 St. Louis Street, downtown Mobile, but the Chapter 7 meeting room is at 182 St. Francis Street, right across the street from Yamble Square. Thank you. I hope this has been helpful.